A retired couple watched water rise beneath their condominium year after year, and the homeowners association responsible for fixing it insisted in writing that the cause did not exist. It was not a small leak. Beneath the building sat something far stranger, and the association would go to remarkable lengths to deny it was there at all. This is a true story. The couple's names and a few small details have been changed. The trial findings, the court orders, and the final figures are matters of public record. It takes place in Santa Clara, California, the heart of Silicon Valley. This is a region known today for technology and glass office towers. But long before the chip factories, this valley was farmland, orchards, fields. And to water those fields, farmers drilled wells deep into the ground. That history matters more than anyone could have guessed. Call the couple Howard and Marlene Pratt. They were retired in their 60s, the kind of people who had worked their whole lives and planned carefully for what came after. They owned a condominium in a complex we will call by its public name, Rancho Palma Grande. They did not live in it. They rented it out, a modest, sensible way to add a little income to a fixed retirement. For a while, it worked exactly as intended. A tenant, a monthly check, a small cushion against the cost of getting older. This is a quietly common story across expensive parts of the country. A couple buys a second property during their working years. They maintain it, they rent it responsibly, and they treat it as part of their retirement plan. It is not a fortune. It is a buffer, money that helps cover the rising cost of growing old in a place like Silicon Valley, where almost nothing is cheap. The Pratts had done everything right. They had planned ahead, owned within a managed community, and paid their association dues so that someone would maintain the shared structure they could not maintain alone. That last part is the crux. By paying into the association, the Pratts had effectively hired it to look after the common areas of the building, the very parts where the trouble would soon begin. They were not asking for charity. They were asking for what they had already paid for. Then in 2018, the tenant reported something wrong. Water was pooling in the crawl space beneath the unit. Not a spill, not a one-time flood. Water collecting underneath the home where no water should be. The kind of thing that does not fix itself and does not stay small. The Pratts did what any responsible owner would do. They reported it to the homeowners association. Here is where a quick word is needed about how a condominium works. When you own a condo, you own your unit, but the structure around it, the land beneath it, the shared bones of the building, those belong to everyone collectively. They are managed by the homeowners association. The HOA has a legal duty to maintain those common areas. It is not a favor. It is a fiduciary duty, the highest kind of legal obligation, the duty to act faithfully in the owner's interest. So the water beneath the unit was not just the Pratts' problem. It was the association's responsibility. At first, the cause was a mystery. Water was coming up. From where and why, no one could immediately say. So the question went to people who investigate exactly these things. Independent experts. Let me stop here for a second. Stories like this only spread when people share them, so if it is holding your attention, tap subscribe. And I would genuinely like to hear how you would have played it. Now, back to it. And the experts found something almost impossible to believe. Beneath that condominium, deep underground, lay an abandoned artesian well, not a shallow pipe. A well reaching more than 400 feet down into the earth. A relic of the valley's farming past, drilled generations ago and then forgotten when the orchards gave way to subdivisions. An artesian well is a particular kind of well. The water in it is under natural pressure. It does not need a pump. Left open or failing, it can push water upward on its own, steadily with the patient force of the aquifer behind it. And that is precisely what this one was doing. It was discharging water upward into the crawl space beneath the Pratts' home. Think about what that means. This was not a leaky pipe that a plumber could tighten in an afternoon. This was the earth itself, pushing water up through a forgotten shaft that predated the building, predated the subdivision, predated perhaps everyone now living above it. The valley's agricultural past had left a hole more than 400 feet deep directly beneath a row of condominiums, and the pressure of the aquifer was feeding it. No amount of mopping or dehumidifying would touch the source. The only real fix was to find the well, confront it, and remediate it, which is exactly what the experts said. It was admittedly an extraordinary claim. A 400-foot artesian well under a condo is not the kind of thing anyone expects to hear. But the experts did not guess at it idly. They investigated, and they reached a conclusion, and they put their recommendation on the record. That recommendation gave the association a clear path forward. The experts laid it out and made a recommendation that was as clear as it was reasonable. The association should investigate the well. It should remediate it. Find the source, address the source, stop the water. This was the off-ramp. The moment the whole story could have ended quietly, with a repair and a bill and a problem solved. All the association had to do was follow the advice of the experts it had been given. It did the opposite. The association rejected the expert recommendations. It declined to investigate the well. It would not pursue the theory that a 400-foot artesian well was sitting under the building, pushing water up from below. And then it went further than mere refusal. It began to deny the well existed at all. The water did not care. It kept coming. Day after day, season after season, the moisture worked into the structure. And where there is standing water and trapped damp, mold follows. The unit began to develop it. The building took on structural damage. Slowly, the condominium the Pratts had bought as a retirement asset became something else, unlivable. Eventually, the unit became uninhabitable. No tenant could stay in it. The rental income that had cushioned their retirement simply stopped. Year after year, that income was gone, while the damage deepened and the association held its position. There was no well. There was nothing to fix. Picture the slow grind of that for a retired couple. The asset they had counted on was no longer producing a dollar. Worse, it was actively decaying. Mold spreading, structure weakening, the value of the property sliding with every wet season. They could not rent it. They could not reasonably sell it in that condition. They could not fix the true cause themselves because the cause sat in the common area under the building, where only the association had the authority and the obligation to act. They were trapped. Their retirement plan was rotting from below, and the one body empowered to stop it had decided the problem was imaginary. Most people, worn down by that, would have given up. The pressure to simply absorb the loss must have been enormous. But the Pratts kept pressing, and the association kept denying, and the dispute began to climb towards something larger than a maintenance disagreement. Now a homeowners association denying a problem to its own members is one thing. What happened next went beyond that. The city got involved, as cities do when a building deteriorates. City officials, inspectors, the people whose job is to make sure structures are safe, looked into the condition of the unit. And the association did not simply stonewall its own owners. According to what was later established at trial, it set out to deceive the government. A newly hired attorney for the association sent a letter to the city inspectors, and that letter made a claim that the trial court found to be false. It claimed there was no credible evidence supporting the existence of an abandoned well, no credible evidence of a well more than 400 feet deep. Identified by independent experts, actively pushing water into a crawl space. That letter was not an honest difference of opinion. It was an affirmative misrepresentation made not to a homeowner this time, but to a city official charged with public safety. The association was no longer just ignoring a problem. It was working to bury it at the official level. Consider the calculation behind a move like that. City inspectors are the backstop, the outside authority that exists precisely to catch what private parties try to hide. When an association lies to the very inspectors meant to protect the public, it is not making a careless error. It is reaching past its own members to corrupt the one external check that might have forced action. The letter was an attempt to make the truth disappear from the official record, and for a time it may have worked, while the water kept rising and the unit kept rotting. And here the story reaches the detail that turned suspicion into proven fact. At trial, the former president of the Homeowners Association, a man named in the public record, Steve Moritz, admitted under oath that he had knowingly spread falsehoods about the presence of mold, falsehoods about the well. This is not an allegation. It is not a theory the Pratts advanced. It is an admission made on the record by the man who had led the board. The person at the top of the association acknowledged that he had knowingly spread what was untrue. Imagine being the Pratts in that courtroom. For years they had been told there was no real problem, nothing to remediate. For years they had watched their asset rot and their income vanish while the association insisted everything was fine. And now, on the witness stand, the former president of that very board admitted he had knowingly spread falsehoods. The case was heard as a bench trial, meaning a judge, not a jury, weighed the evidence and rendered the verdict. The judge was Joanne McCracken of the Santa Clara Superior Court, and when she had heard it all, the well, the experts, the rejected recommendations, the letter to the city, the admission from the witness stand, she made findings that named the association's conduct precisely. She found the Homeowners Association liable for fraud, for affirmatively misrepresenting the truth to the Pratts and to the city. She found it liable for negligence, for failing in its fiduciary duty to maintain the common area and address the water. These two findings already tell a complete story. The association had a duty to maintain the shared structure. It breached that duty by ignoring the experts and refusing to act. And it compounded the breach by misrepresenting the truth, first to the owners it was supposed to serve, then to the city it was supposed to be honest with. Fraud and negligence side by side in a single set of findings. For an ordinary defendant, that alone would be a serious judgment. But the court went one finding further, and it is the finding that defines this case. And she found it liable for elder abuse. That last finding is the one that changes everything, and it deserves explaining. California, like many states, has a specific law protecting older adults from financial and other abuse. The state's elder abuse statute exists precisely because the old are so often the targets of exactly this kind of conduct, worn down, taken advantage of, deceived by parties who assume they will not have the strength or the resources to fight back. When a person is a senior citizen and they are harmed through fraud or neglect by someone with a duty toward them, the conduct can rise to elder abuse under the statute. The Pratts were retired seniors. The association had a fiduciary duty to them. It deceived them and let their property be destroyed. The court found that this crossed the line into elder abuse. The elder abuse finding was not a label for emphasis. It carried legal weight. It opened the door to punitive damages beyond the ordinary limits, penalties meant not just to repay a loss, but to punish conduct the law treats as especially wrong. Then came the number. The trial court awarded the Pratts $1,800,000, $1.8 million. The award covered the lost rental income year after year of it. It covered punitive damages, the penalty for the deception. It covered emotional distress, the human toll of watching their retirement asset destroyed while being told nothing was wrong. And according to the reporting, that figure was the largest financial award ever entered against a homeowners association in California of its kind. Not a large award. The largest. A record set by a retired couple who had simply reported water in a crawl space. For most defendants, a $1.8 million judgment would be the end. The association did what associations with deep reserves often do. It appealed. It took the case up to the California Court of Appeal. This is the higher court, the one that reviews whether the trial was conducted properly and whether the findings hold. It meant more time, more cost, more waiting for a couple already years into the fight, already out their income, already worn down. An appeal is its own kind of pressure. It does not retry the facts, but it can unwind a judgment if the higher court finds the trial went wrong on the law. For the Plotts, it meant that even after winning everything, nothing was truly final. The $1.8 million award sat in limbo. The association, with its reserves, could keep the fight alive while the couple waited. For people in their later years, that wait is not a small thing. Time is the one resource they cannot replace, and the association was spending it freely. On August 28, 2025, the California Court of Appeal ruled it upheld the judgment in full. In full. Every finding. The fraud. The negligence. The elder abuse. The $1.8 million award. The higher court examined the record, the letter to the city, the admission from the former president, and it agreed with the trial judge entirely. As of that ruling, the sources note no further appeal. The matter was, by every available account, finished. The Pratts had won, and the win was final. It would be satisfying to stop there on the courthouse steps with the number affirmed. But the harder truth belongs in the ledger, too. This took years. The water began rising in 2018. The judgment was not affirmed until 2025. Across that span, the Pratts lost their rental income, watched their property become uninhabitable, and were told again and again that the cause did not exist. They were retired. They were in their 60s when it started. They spent a meaningful share of their later years fighting an association that had a legal duty to protect them, and chose deception instead. Justice arrived. It arrived large, and it arrived final. But it did not arrive quickly, and it could not give back the years. So why does this story matter, beyond the shock of an abandoned well beneath a home? Because the mechanism is the lesson. The Pratts did not win because their situation was sympathetic, though it was. They won because the truth was provable, and because a court was willing to look at the record and follow it. The experts identified the well. The letter to the city was a documented falsehood. The former president admitted his falsehoods on the stand. Against that record, denial could not survive. A homeowners association holds real power. It controls the common areas. It speaks for the building. It can reject expert advice, refuse to investigate, and insist to its own members and even to the government that a problem does not exist. Those powers are heavy, and they are often enough to wear people down. But they are not the final word. Above the board sits a court that does not care how confidently a letter was written. It cares what the evidence shows. There is a sharper lesson here, too, about who these cover-ups tend to target. The Pratts were older. They were not in the unit daily. They were, in the law's eyes, vulnerable. And the law recognized that vulnerability and answered it with the elder abuse statute. The very thing that may have made them seem like easy people to deceive became the legal finding that multiplied the penalty. And there is the matter of the fiduciary duty, the thread running under all of it. An association does not merely have the option to maintain the common areas. It has the highest legal obligation to do so faithfully. When it instead chose to deny, to deceive, and to let the property rot, it did not just make a mistake. It betrayed a duty the law treats with great seriousness, and the size of the judgment reflects exactly that. Still, the final tally is clear, and it is the kind of tally this channel exists to read aloud. A retired couple reported water beneath their home. An association rejected the experts, denied the well, lied to the city, and let the unit become uninhabitable. Its own former president admitted spreading falsehoods. And when the courts had finished, that association was found liable for fraud, negligence, and elder abuse, and ordered to pay $1,800,000, affirmed in full, the largest award of its kind in the state. Beneath that condominium, the old well is still there, 400 feet of the valley's forgotten past. For years, the association swore it did not exist. In the end, a judge, an appeals court, and a record-setting judgment said otherwise. The water was always coming up. And eventually, so did the truth. Justice. Served quietly. Some debts get paid quietly, and this was one of them. If you enjoyed it, subscribe to Quiet Justice and ring the bell for the next story. And let me know below, would you have shown the same patience? Thanks for watching.